until you start 60 minutes. We have unlimited amount of time.
Don't abuse that. All right, well, why don't we go ahead and get started just so that we can enjoy what's left of Friday.
I think it's Wednesday.
No.
It's Wednesday.
Today's Thursday.
Can I just,
My Friday.
can I point out, yeah, my first comment will be, in fact, it's Wednesday, Mike.
Thank you, and that's the kind of insight that we brought Mr. Parker here for. We're going to go ahead and get started. Our last panel of the day discussing nascent competition is to take on the very real-world problem of how you go about identifying cases that actually raise competitive concerns, and then how you challenge those cases, and certainly focusing on the world of mergers and acquisitions. For that, I am joined by a panel of very talented antitrust lawyers, people I've worked with over many years of my career, and several of whom have held top positions at the FTC or the Department of Justice. To my immediate right is Rich Parker. He's a partner in the DC office of Gibson Dunn and was formerly my boss, director of the Bureau of Competition. Next is Debbie Feinstein. Debbie is a partner in the Arnold & Porter law firm. She also was a former boss of mine as director of the Bureau of Competition and held other positions in the FTC. Next to Debbie is Dave Gelfand. He's at the Cleary Gottlieb law firm, and he was former Deputy Assistant Attorney General at the Department of Justice. I did not work for Dave. Next is Ray Jacobson. Ray is head of the McDermott, Wilmot, and Emery antitrust practice. And then, now I'm losing sight of the order here, but it's Andrea Agathopoulos Marino. She is with Goodwin's antitrust group here in DC, former attorney advisor to Chairman Kovacic at the FTC. And then Scott Scher at the very end, he heads up the antitrust department at Wilson Sonsini. So a tremendous group of litigators and antitrust lawyers who I hope will help us shed light on some of the really complex issues that we've talked about over the course of the first couple of panels this afternoon. Scott, to start things off, can you explain to me from a practitioner's perspective what we're talking about when we're talking about a nascent competitor? Is that just a potential competitor, or is that something else?
Sure, Mike. I don't think that there's much of a difference from a practitioner's perspective, but obviously there are case law differentials. Potential competition is defined in case law as either actual potential competitor or a perceived potential competitor or a potential competitor. And whereas I think it's correct, the last panel talked about nascent competitor being generally described as a company that has a promising technology. This was from the Microsoft case, that may or may not be able to bring that technology to market and may or may not need assistance in bringing that technology to market. From a practical perspective, in most deals where you're dealing with small technology companies, you tend not to define them as potential competitors just because that you have the framework from the guidelines. It gives you less flexibility as to how to characterize them. And more often than not, we define these small companies that have interesting and important technology potentially as nascent competitors.
Mm-hmm. Debbie, does that make a difference in how the agency or how you would analyze a merger?
Okay, so first it's a little funny to be having Mike ask the questions rather than answer them, because he's thought about this more than any practitioner, since much of what the division does is potential competition type cases in pharma and elsewhere. So a couple of points. We all think of Section 7 as requiring some degree of likelihood that it will lead to problems, and so where on the spectrum you are is a little unclear, and there hasn't been a lot of case law. We tend to use the word nascent when we're talking about a Section 2 Mallinckrodt type case. No particular reason for that. So I agree that some of the terminology gets blurred and that it's really not that important to talk about the technology. What you're talking about is what's the status of the acquired firm, let's call it the acquired firm, it could be the acquiring firm who's the new technology person, but what's the status of the acquired firm and what will be the effect on competition if it's acquired by the entity that it's being acquired from, and the labels we put on it. I think if you go back and look at the complaints during the time that I was there, I'm not sure we ever used the phrase potential competition, we used the phrase future competition, because in the pharma world, it's not so potential. Once somebody has actually filed with the FDA, the likelihood that they're actually going to come to market is extraordinarily high. So we would talk about future competition. I will say one thing, I've never figured out how one could actually ever bring a perceived potential competition case, because the moment you bring it, the acquired company is going to say, well, that's kind of crazy that they perceive us to be a competitor because we're not doing anything. And once that fact gets out there, you've changed the market landscape just by bringing the case. So I think that's one of the reasons you don't see a lot of perceived potential competition cases. But fundamentally, the labels you put on it aren't the question. The question is, what's the competitive impact going to be? And then, and we'll talk about this more, how would I prove that there's going to be that impact? I don't think that the box is also narrow of the information that we're putting it in. The guidelines tell you don't have to start with this methodical, what's the market definition? You're asking the question of, are things going to be worse for competition and consumers? And I think the box is pretty big to put a lot of stuff in to get to that question.
I should have mentioned this at the outset, but this panel is a little different from the previous ones. We're not sort of having introductory comments by everybody and rather just jumping into questions. That also means that there's greater opportunity, or hopefully significant opportunity, for audience participation here. So as we go along, please submit any questions that you have, and we'll try to take them on, time permitting, as we go through this. So with that said, I wanted to raise the question of whether there are any special attributes of high technology markets that affect merger analysis. We've spent a lot of time over the course of the last few days talking about platform competition, and some of the attributes of high technology markets are certainly focusing on mergers. Andrea, can you shed some light on that question?
Sure, I'm happy to. And I just wanted to thank Mike and everyone in OPP for organizing and for having me here today. I agree with what Debbie said, that the purpose here is really all about getting to what the competitive impact is. But I think fundamental to that is understanding that there are some differences when you're looking at these kinds of, at certain kinds of high-tech deals. And the one word that always pops into my mind is speed. And the pace of play here is just different than it is in other industries. And I think that has a very meaningful effect on the way that the agency has to go about gathering the facts and assessing the evidence. These markets can be very fickle. These markets are capable of being upended quite quickly. And because of that, some of the data that we provide to the agency, to the DOJ as well, by the time you provide it, it's already old. Time has already passed. And so when I'm working on behalf of clients trying to explain competitive dynamics, I find that that's one area where you have to really make sure everybody is on the same page. If there is not an appreciation that things can change on a dime, you're not really able to look at the nuts and bolts of the market in a way that I think is capable of making an accurate prediction, which obviously is what you're trying to do in a merger case.
Well, if that's the case, is nascent competition something that raises particular problems in these rapidly evolving markets? Ray, do you want to weigh in on that?
Well, the answer is certainly nascent competition is more important in high-tech markets than in bricks and mortar markets, because I think in high-tech markets, as we've been talking about throughout your hearings, your concern is innovation. So going back to what Paul Dennis was teaching us earlier, you have to ask a bunch of questions. How serious, how substantial is this particular nascent competitor? If they're unique, if they're special, that's one thing. If they're one of a handful, then the loss of that one is not such a factor. Your question talked about the evolving nature of the market. From looking back at all the cases that have been investigated, to my knowledge, over the last 10 years, the dynamism of high tech is very, very important. And we've seen major companies make acquisitions, but have them approved or not challenged by the agency because of the dynamic nature of the industry. So I think there's a strong defense, the dynamism defense, to the concern, but it's clearly a concern in any high-tech market.
So, over the last couple of panels, the notion has been raised that the agencies really are not or lack the capabilities of fully appreciating the nuances of how these markets work. Andrea, can you give me an idea of what kind of information the agency should be prioritizing when they're looking at a merger in one of these markets?
Yeah, so I don't recall exactly how you phrase it. I don't think it's an issue of that the agencies aren't capable of understanding. I think this is really hard to do. And I think that what is very meaningful and what's very helpful is being able to talk to business people. That's probably the number one thing I would say that is a little bit different from some of the more brick and mortar industries where you have companies that have spent a lot of time developing strategic plans. They have full-blown corporate development units that think about corporate strategy for the long term. Here, some of the folks that I work with, there's just one guy that has an idea and he doesn't write anything down. So from my perspective, it's a challenge sometimes to get the agency to really want to listen to that one guy's vision because the agency immediately assumes that it's just self-serving and that they're just saying whatever needs to be said to try and get the deal through. And I think that that's not always the case. I think that a lot of times because these markets move so fast, because things change so fast, you really do have people who are the key intellectual asset that will tell you what the future is going to look like. So that's one category of information I would encourage the FTC to more willingly embrace. It's when I bring in that guy or that woman that's going to be able to explain to you what they're thinking and what they have in mind. It's not because I've spent hours prepping him or her trying to tell them all the buzzwords. It really is because this is the person that has all the information in his head. Now, that said, there are lots of documents that are around. I mean, Scott and I were involved in Bizarre Voice, and everyone will remember what those documents looked like. We were just talking about that with David. But I think that, looking for the traditional asks are also perfectly appropriate. I also liked some of the ideas that came from the earlier panel with John Newman and Lena Kahn. Lena mentioned, usage level of rival apps. I'm not sure that that's a level of data that people really think about when you get into certain kinds of deals, but that could be meaningful. And I like John's suggestion for A/B testing. Now, all that data does come in certain deals, and I've seen it at the DOJ, I've seen it at the FTC. I think what would be helpful is for the FTC perhaps to develop a more standard ask of some of these high-tech deals and say, okay, if you're doing a pharma deal, when Mergers One sends a voluntary access letter, we know exactly what they're going to ask for before they send it. They're experts. They've signaled to the market, to people like my clients, what they're going to want to know. I don't think we've had the same force of messaging when it comes to some of these high-tech deals. So I think that maybe coming up, spending more time revising what the voluntary access letter would look like in a high-tech deal to include some of these more odd requests would be something that could be useful.
So speaking of that, we've had actually some remarkably spirited debate about whether the FTC should have on staff technologists or technology experts either embedded in the Bureau of Economics. Nobody wanted them embedded in the Bureau of Competition, which I think is sort of remarkable, but or a standalone group. What do you think, maybe Andrea, if I could just stay with you for a second, can you tell me what your thoughts are on that?
Yeah, I think it's a good idea. And I'm not quite sure where some of the hesitancy comes from, because I think if you look at, again, I'll just use Mergers One since Mike is up here, we all know they're pharma experts. And they are really good, that staff is really good at pattern recognition. You don't have to explain certain fundamentals of the industry to them because this is all they do day in and day out. I think having a tech team at the FTC, perhaps modeled, perhaps not, after what the DOJ has in there, I guess they call it technology and financial services now, what was NetTech. But I think that that's a good idea. I think that anytime you have people who get exposure to the same issues again and again, they become faster. They become more able to analyze things more quickly. I think it becomes just a more efficient work stream. So I think that would be valuable. I had never thought about Danny's idea of hosting them in BE, but I think that's something to be explored for sure. And I certainly would, I think I appreciate the value of the specializations. People ask me all the time, can you look at my will? Can you do my tax returns? I always say, I'm not that kind of lawyer. So why not have an FTC shop that says, yeah, that's kind of the industry I focus on. I recognize it's broad. I recognize there are differences between, not all tech deals are the same, but it just seems to me that there's a value there in having people who have Google alerts set up to get breaking news about certain industries, and that's what they think about day in and day out.
Well, I think, as John Yoon said, I guess you can't be anti-technologist, or maybe you can. Debbie, you headed up the Bureau. Tell me what you think about that.
Yeah, I don't get it. So, Mergers One doesn't have any pharmaceutical experts. Last I checked, they don't have anybody who went to pharmacology school. They're lawyers. They're really good lawyers who dig into the facts of each case and have developed learning about how the industry works from working on those cases. But I don't know what a technologist does that would apply to the vast number of industries that we're talking about that are high, that are technology-based, that are fast-moving industries. And I also think that once you become a government employee in Washington, D.C., your connection to the tech community that might give you the ability to really have your hands close to what's going on might just on the margin diminish, is a guess. The way the agency deals with that is to talk to anybody it can, and it does. That's one of the great privileges of being in the government is you pick up the phone, and for the most part, people talk to you. Professors will talk to you. Experts will talk to you. You can get most of the information for free, although if you really need to hire an expert because you want them to testify to something or to consult with you on something, there is a budget for that as well. But I think the number of technologists that you would need to make a difference, to have somebody for each of the technology areas that the government would look at, and the fact that you may go 6 months without a case in that technology area coming up. So what would that person do? I really just don't think it's the most effective use of resources. To the extent that somebody thinks that there is information out there that the agency isn't getting and the kind of person and where they should get it from, that's something to talk about, and it would be interesting. I haven't heard somebody say, in this investigation, the FTC missed talking to these kind of people at these kinds of companies, and therefore they missed that the future was here, and they thought the future was there. I just haven't heard that kind of criticism. So I'm with John on this one, that I don't think that's the most effective way if there is an information gap to fill it.
I have an opinion, and that is, I was bureau director when they started the patent group, and I think that was a big success. And these were lawyers in the Bureau of Competition, and I think they immediately contributed. I think that if I was an enforcer and I saw all this talk about platforms and nascent this and all this technology, I would want a lawyer in the Bureau who has broad experience in dealing with tech industries, who knows what questions to ask, who's had experience, who has represented startups, has represented big companies, small companies, just that experience. So there would be somebody, when we're charging up the hill here, I could ask, do you think we have all the right data, and do you think we can win this? And I think it would be helpful to have somebody who had broad agency experience in the tech area to duplicate what Merger One, for example, has in pharma. That's just, if I was in charge of this, that's exactly what I would want. Go hire Scott. There you go.
But you're talking about a lawyer.
Right.
That's what I'm talking about.
And, yeah, I think there's a difference between lawyers and technologists, and not
Right.
to be an apologist for the agencies. I think that there are probably 50, 75 lawyers within the FTC and DOJ currently today who understand technology markets extraordinarily well. You have platform markets in real estate, for example. You can go talk to Jessica Drake, who's done a number of the large deals there. You have a question about Google, you can go talk to Stephanie Wilkinson, or you can go talk to Barbara Blank. These are people who understand generally what to ask for and the sorts of information that they need to accumulate when they are conducting an investigation into one of these markets. I personally find it to be scary almost to consider having actual technologists at the FTC for some of the reasons that Debbie had mentioned. There are not enough deals in any one given tech market. Tech is not a market, by the way. If it was, then every deal can go through. There are many subverticals in technology. There are many subverticals in search. There are many subverticals in advertising. You can't ask somebody who's an expert in one of those verticals to analyze code in another vertical and say, was this written properly? The other problem is, and the really scary thing from my perspective is, if you have technologists who you're asking to go back and look at code, you're asking a technologist in some instances to go back and look at code that may have been written 15, 20 years ago and had been altered over time to accommodate specific problems that existed at the time that the code was written, that somebody is analyzing today with a gloss that's completely irrelevant to the time when the code was written. So how do you solve that problem? Well, I think you solve that problem the way you solve the problem in every single merger review. You look at the documents, you look at the developer notes at the time they were written. So instead of going back and trying to discern what the source code is, every single developer who writes code keeps a journal and says, this is the code I'm inserting, this is why I'm inserting the code, and they're not thinking, well, in 20 years I might be investigated by the FTC, so let me not tell the real reason why I'm doing it. They actually say, I'm doing it to solve this problem, or I'm doing it to frustrate this issue. So go back and do what you would do in any single deal. Talk to the engineers, review the documents, talk to the executives, talk to industry experts. Again, I think, I've had the good fortune of working on a lot of the deals that have been mentioned today involving, in Google Waze, Zillow Trulia, Google AdMob, FanDuel DraftKings, Bazaar Voice. Some of them have gone my way, some of them haven't gone my way. But what I can say is that the agency analyzed the deals correctly in every instance. I might not have agreed with the outcome. Maybe I think that they've weighed certain factors differently than what I would have weighed them as. But all the things that people have been talking about over the course of today, the agencies do already, and they do it quite well. A/B testing, well, I can tell you that, in an investigation with Barbara Blank, we probably produced 10,000 A/B tests to staff, and they reviewed them all. So, the agencies, trust me, the agencies understand how to analyze these deals. They're doing it in a way that's consistent with merger policy and with the law. And to contemplate changing it because we're dealing with something that's called tech, I think is dangerous. Because sure, there are unique characteristics of technology. There are unique characteristics of grocery stores. There are unique characteristics of pharmaceuticals. There are unique characteristics of defense industries. I think the intense focus on technology, in my opinion at least, is misplaced. The agencies are doing a pretty darn good job in analyzing these deals. And I don't think that we really need to change the way they're doing it. To the extent that people have fundamental problems, to me it sounds more like a legislative concern and people want a different standard to be applied to the review of technology deals. But that's not a job for the FTC or the DOJ. They're doing it right. If you have a problem with that, you got to go to Congress. I'm sorry, I might have gone off a little bit on that.
Any comment that ends with "call your congressman" is fine by me. Having wrestled that issue to the ground, maybe I'll move on to sort of more substantive issues and away from the process. Debbie, you and I have talked many times over the years. I'm going to jump back into the boxes now of antitrust. That is unfortunately the world I think that we live in. And looking at a potential competition case, I think most of these, in my experience, revolve around how likely the entry has to be before it raises a competitive concern in a merger case. What is your sort of sense of how likely the entry has to be to trigger a Section 7 issue?
Yeah, so I mean, the courts haven't really given us a lot of guidance on this. So in some ways that's freeing to the agencies to say, we're going to figure out the level of likelihood that seems right to us. until the court tells us otherwise. And I don't think that the commission staff follows the BAT clear proof standard, unless you define clear proof as something different than I do, which is absolute certitude, 100%, and there's no possible obstacle that in the next 2 years until the product is on the market, something could go wrong. I mean, if that's the definition of clear proof, that is clearly too high a standard. But it's got to be something more than a case I worked on once that ultimately did not go when I was on the outside, and the staff did not end up proceeding with it, but it was somebody very low level thought of, entering the product, and the staff's theory was, well, you really need to be in this product because others in your space are in this product. I mean, that's not sufficient to go on. What you want to see is that there's a bunch of evidence that all points the same way, that there's, an intent to enter and that it's at a fairly high level, that there are people high enough in the decision-making chain to have made a decision to put real investment and effort behind something. By definition, future entry is not certain because something can always go wrong. But, are you taking clear steps to it? Are you putting real money behind it? Are you talking to customers about it? I always found it sort of astonishing when people would come to us and say, oh, no, we're really not going to enter. It's like, you're telling your customers you're entering into contracts with them. How can you come try to tell me that you're actually not making real steps to enter this? So, I mean, it's a bunch of different factors that really go to the question of, does the evidence point in one direction as opposed to another direction? It's really the question of why in pharmaceutical deals we look at things that are fairly far along, not when there's just a named molecule, because there's so many things that could go wrong. We don't say that it's likely, and because the investment hasn't been made. But I think that for the most part, there's not a whole lot of confusion about the kinds of cases that will raise questions of potential entry, future entry. So I don't worry that there's some big gap in the, between the outside lawyers and the commission staff as to what it is we're talking about when we're talking about entry likelihood.
Well, let me take that a little bit further, because if the evidence sort of has to point one way or another, or is that there's some significant probability of entry, doesn't that necessarily mean that you're going to lose the ability to challenge potentially anti-competitive deals where the entry is less certain but is greater than zero? Dave, do you want to take that question?
Yeah, thanks, Mike. First of all, let me begin by also thanking Bilal and Stephanie and Elizabeth and the policy group for organizing these hearings, and also for inviting me, especially for inviting me to participate on such a great panel with such great fellow panelists. I'm grateful for that. So, Mike, this is something that I think is addressed in the case law. I think it's addressed by the standard of the burden of proof. I think it's addressed in the guidelines themselves. Section 1 says, merger analysis, quote, requires an assessment of what will likely happen if a merger proceeds as compared to what will likely happen if it does not. And I think it's a dangerous thing if you start going down the road of saying that we're going to have situations where something is not more likely than not, but we're worried about it. And we create a law that allows the government or a plaintiff to go into court with a nebulous standard of worry. I think you've got a burden of proof. You got to prove by preponderance of the evidence, if you're a plaintiff, that the transaction is likely to substantially lessen competition. And doing that means proving that the entrant is likely to come in for the most part. Now, a couple of things. I want to pick up on one thing that Ray said, which is you have to think about the uniqueness of this potential entrant, this nascent entrant. One thing that I think was a little lost in all of the discussions that I've listened to today is we talk about large companies buying nascent competitors, but very little discussion about what the other nascent competitors are out there. Oftentimes, these are markets where 10 companies have entered in the same way. And so there also has to be some uniqueness about the nascent competitor or the potential competitor that's being acquired. And Mike, when you guys looked at Google DoubleClick, you, and I worked on that, I should just say as a disclaimer, but you pointed that out in your closing statement that there needed to be some uniqueness there. And so I think that's another important dimension to this. Let me also say that I don't think we need special rules for nascent competitors in certain types of tech businesses. I know that just echoes what a lot of other people have said, but I think maybe I'll make this point. And this actually picks up a little bit on Scott. Lawyers in the government are damn good at looking at these cases and damn good at building cases based on the documentary evidence, the data, testimonial evidence. They have enormous power to compel testimony in the investigative phase, and you're good at doing it. And the one thing I would say is you're even better than you think, because I think you could make these decisions a whole lot faster. And if I had one thing to say to the agency on this panel, I would say, and this does apply especially to some of these technology markets, you got to make these decisions in fairly quick order. Sometimes the markets are dramatically affected simply by holding up a deal for a year during an investigation and then another 6 months during litigation. Get your investigation done in 3 or 4 months. You can do an enormous amount of work in 3 or 4 months. You can get a lot of documents, you get a lot of data, you've got big teams that work on these cases, and that's the best way to enforce the law in this area, not try to create a special standard or, sort of put the thumb on the scale. And by the way, one other thing. Why would you create a special standard for an area of competition that is the most speculative? It's the hardest one to say there's actually going to be harm. Are we just trying to create rules that make it easier to bring cases? That shouldn't be what's going on here. You should live by the rules that exist. If you can't prove a case, then go out and develop better evidence about what nascent competition means, about what the effects are. Do the kinds of studies that some of the panelists today have talked about doing. But you got to do more than just come on to panels and talk about it. You got to publish your results. You have to convince your peers in the scientific area that you practice in, whether it's economics or technology. You've got to convince them that there's some consensus around the science that you're developing so that you can then take it to judges and admit it under the rules that apply to expert testimony. So that's what's going to have to happen, not create a new standard that just makes it easier to bring the cases.
Wow. So I'll remember that next time I call on you, Dave. I appreciate the admonition that a little harder work on our side is all that's necessary to get to the prompt resolution of your clients' cases. We should have had Paul Dennis up here. He would have been the Grecian chorus telling you how that's the singular metric to measure agency performance by. Let me shift to something that really is at the heart of any antitrust case, and that's how do you measure effects? So all of these cases boil down to what's your story of anti-competitive effects? And in a potential competition case, you don't have necessarily the historical experiences to draw on that often color a lot of these cases. What do you do? I guess, Scott, I'm going to call on you, even though it's sort of unfair, because I'm going to ask you to explain the government side. If you're trying to prosecute a case, what kind of effects evidence would I look to try to show that these transactions are anti-competitive in the absence of that type of historical experience?
Right. So that is one major difference between transactions in these markets and transactions in traditional brick and mortar deals. A lot of the competitors don't really have a track record of experience. But like what I've been talking about before, they're the same tools that are available during investigations in these potential competition or nascent competition cases that are available in traditional cases actually do work. So what are some of the things? Why does the acquiring company want to acquire the nascent competitor? What is the pro-competitive justification for doing it? Is it output expanding, or are they concerned about whether or not the company that they're buying represents a potential competitive threat to their position in the market? And I'll give one example. In Facebook, Instagram, which, again, I think that the agency analyzed using the correct framework, I represented a third party in that case, so I had a vested interest in maybe concluding that the transaction was problematic. But if you look at what Mark Zuckerberg actually told his investors at the point of time when he wanted to acquire Instagram, which was on the eve that Facebook was going public, he stated that it was a defensive acquisition in order to make sure that Facebook remained in the competitive position that it was in before. That's pretty compelling evidence as to, one, why a transaction is being contemplated, and two, what the best expert in the industry, the incumbent firm, believes is the potential effect of the transaction. So I think, again, the most important evidence in technology deals is the same evidence that's available in most other deals. Why is the deal being done? What do ordinary course business documents say? What does the potential competitor believe that its position is going to be going forward in the future? And what do other people in the industry believe that that potential competitor represents? Just staying with the Facebook, Instagram example, one potential thing that you might want to look at, and it's something that Andrea had mentioned before, is what are the usage statistics of Instagram? There were 10 or 11 or 12 other photo sharing applications that were in existence and relatively similar in funding size to Instagram at the time that it was acquired by Facebook. What were the usage statistics? It's interesting, if you looked at the mobile usage statistics of Instagram versus some of the other competitors that were available on the market at the time, Instagram was actually doing pretty well. Now, there were substantial challenges, and I understand why the agency didn't bring that case. Instagram had been founded less than 12 months before. Instagram had 11 employees, and Instagram really had come up with a photo sharing app. So it is a really difficult case to prevail on if you wanted to bring a case like that to court. But if you're considering what are the sorts of things that I should be looking at in deciding whether or not a potential competitor is relevant, they're there. You have the evidentiary tools to decide whether or not on balance it's worth bringing the case or not. And again, the agency gets it right. You guys look at the right data. You know, you might not weigh it in the same way that I would have weighed it, and you might have, a conflict as to what is the proper enforcement role of the agency. Should you intervene early to ensure that as many competitors can develop as possible, or do you allow the market to operate the way it would absent regulation? And that's a philosophical reason to block or not block a transaction, and that really just goes to whether or not the decision maker weighs the evidence in the same way that other third parties would. So again, Mike, it was a long answer, but you don't have the pricing evidence, you might not have the market experience evidence, but there are indicia that exist in these markets to determine whether or not you think it's likely that a company that's developing is going to be successful going forward.
Thanks, Scott. And I do want to we'll spend a couple minutes talking about some of these cases specifically. I think that would be helpful to hear from you guys. And maybe we've already had the preview on Facebook, Instagram. I wanted to quickly ask Dave about whether it would make sense from a enforcement perspective, whether we should have presumptions in potential competition cases. So in the normal Section 7 case, you establish a market, you establish market shares, the government has made its presumption out. You don't have that tool available in potential competition cases, and the real question is whether that would be something that would make this a more predictable and sort of a little less Wild West area of the law.
I don't think there should be a presumption. I know that probably doesn't surprise you, but I don't think we have enough experience, and nobody has articulated what are the characteristics of a potential competition case that you can look back on a body of experience and say, well, here is a certain set of characteristics, and those usually result in anti-competitive effects. There just haven't been enough cases litigated. It's a little bit like the Supreme Court saying per se rules should only apply once you have a certain body of case law finding time and time again that something is anti-competitive. And it's not just the absence of cases finding anti-competitive effects that you can say there's enough there to create a presumption. But as far as I know, an awful lot of these transactions are pro-competitive for the reasons other people have discussed. They give small entrants like Instagram at the time Facebook acquired them, a platform. They give it technology synergies. They give it capital, engineers, distribution. And so how are you going to create a presumption in a set of cases where, arguably, most of the transactions that we're familiar with have actually been pro-competitive? So I think it's, very different from concentration measures in existing competition cases.
If I could interject, I think we kind of do have a presumption, which is the concentration measures. I mean, a lot of times what we're trying to predict, maybe not as perfectly as this is the HHI, is it one of only a few entrants? Is it going to be 4-3? Is it going to be 3-2? I mean, that's what we do, we did when I was at the agency in the pharma mergers. So I think just broadly there is our presumptions, but they're totally in line with, do we think this company is going to come in and be significant? Because if it's a market at 1,600 and we think that the entity coming in is going to get a 2% market share, well, then we don't worry about that. But if we see lots of evidence that this is a company that's going to come in and, take the world by storm and have a really big market share, then I do think we do. So I don't think we need new presumptions, because I think we're sort of, even though we may not always articulate it quite as clearly, we are thinking in terms of the concentration levels and the market structure issues that worry us normally, and we're just sort of applying the same, but trying to get at it with different kinds of evidence. I mean, when you look at the cases that we did when I was there, where I just remember those better, the evidence would suggest that multiple companies were thinking about the industry and the impact of a new entrant the same way. In Mallinckrodt, there were two different companies that maybe were going to acquire the assets of the acquired entity that instead got bought by the dominant firm. And both of them had very similar internal documents in terms of how quickly they could get to market, what the market share was going to be, and what the price effect was going to be. And that's pretty good evidence, and it fit into there's only a couple of people who are going to do this, it's going to have a significant market share, and we're able to show the actual effect on competition, because they have both predicted very similar to each other what price they would be able to come in at, what the uptake would be, and therefore how the market would react.
Okay, so I've been on approximately 1 million panels with Debbie, and I've never disagreed with her before, but I have a slight disagreement. What you described is not a presumption. It's proving the case. Okay, once you carry your burden of proof and you demonstrate anti-competitive effects, fine. Then the burden obviously shifts to the other side to rebut that prima facie case. But I think that's different from a presumption.
Well,
Okay,
I think-
fair point, but to just say one more sentence, which is, I really don't think that there's a presumption in the normal horizontal case, because if you think that anybody at the agency ever sits down after they say, and the market shares are, in the highly concentrated range, I'm done, Your Honor, you haven't listened to a case lately, because they always go on and do the rest of the analysis. So I do agree.
Yeah, but it sure gets you off to a good start in court, having been on the other side of those cases. Your Honor, this thing is presumptively illegal. We got the presumption at this table. I don't know what they have at the other table, but it's not a presumption. That's a good start. I think that antitrust is an interesting kind of common law, because it moves with economic learning. I mean, Philly Bank was based on certain economic learning at the time. Query how long that's gonna last. You look at Legion, antitrust law moves with the economics. It just does. But what I've heard today is we do not have enough information to create a special presumption in this area, and so I would say no, there should not be any presumption here, because we don't know what it ought to be.
Well, let me sort of move even further out on the limb, and that is, I think John Yun called it the potential. Maybe there were 3 potentials in there before he got to the competition part of the case. Mergers involving firms, both of whom are developing products for a market that has yet to come into existence. Ray, is that the kind of case that is out of bounds for antitrust? And if it's something we should go after, how do you go about doing that?
Well, I think there'd be 2 questions that the agency would have to prove to challenge it. One, that there is an unmet need that is going to come into existence. And secondly, that you have the two merging parties that would be two of the strongest competitors. But I think that both agencies have done this a lot. I mean, Rich and I have worked in the defense industry, and of course, there, most of the products are in the future. They don't really know what's the next generation of satellite or weapons system. But what they're concerned about is if we do a next generation satellite, you know, are the two merging parties the strongest competitors? So that issue, I think, would apply with equal force to the high-tech industry. If you can find that the two merging parties are, from their documents and their people and the third parties, the most likely competitors for an unmet need, and you have to identify what that is, and it needs to be in the reasonably near future, then clearly I think that's an easier case, really, I think, for the agency to prove, because it's got substantial facts about the merging parties and what they can do, so they can focus on, okay, how do we articulate what that unmet need is?
Let me shift away from, I'm sorry, Debbie, do you want to wait? So we faced something like that in Nielsen Arbitron. I don't know if you had any thoughts on some of the challenges. That was a case we did together.
Sure. I think it really depends on the facts of the case. Sometimes it's very easy because you can define the market. You know, the only two companies developing a generic pharmaceutical product, I mean, that is a really easy case to bring, right? Which is why they always settle, because you can clearly define what the market is. It is the generic, you know, whatever. Sometimes, and Nielsen Arbitron was one of them, and if you go back and look at the complaint, it's a long description of the product market. One FTC economist once told me that I probably was on thin water if I had too many dashes in my product market definition. And Nielsen Arbitron comes, you know, close to that in the sense that there were a lot of adjectives, but it's how the customers described the market to us. And so, you know, it's going to be tougher when there's, a debate about how exactly do you say what it is that's being developed when it isn't done. I don't think that ought to keep you from trying to say, hey, look, this is the problem that's being solved. And in that case, it was a problem that was being solved, which is bringing together data from, TV viewers and radio viewers and online viewers and putting it all together. I think it's an articulation issue, and, that's always tougher for, to have to tell a story in court, but it can be done if you have the facts to show, hey, this is what they're out touting to the marketplace they're going to do, and the customers are saying, yeah, they came to me with this solution. I may not call it the same thing as the customer down the street, but we all know what we're talking about here. You just have to be able to explain that all to a judge.
Mm-hmm. So let me talk about a slightly different situation. That's not a firm that sort of has the idea of entering a market, but a firm that's actually entered the market. So it's sort of day one of their entry. Small share, they're just getting started. Is that analytical framework different? Andrea, do you want to weigh in on that?
Yeah, I think that this is a boring answer, but I don't really think the analytical framework is any different for all the reasons that we've heard on this panel and also on some of the earlier ones. To me, I don't know if Professor Yoon is still here, but this is about the evidence, the Marsha, evidence. And so I think that maybe the caliber of evidence, maybe the quantity, maybe the quality will vary slightly, but I don't think that you need to have there needs to be a difference in the analytical approach. I do think it's pretty well settled that the way that the FTC and the DOJ go about analyzing these deals in terms of that framework is appropriate. But I think that understanding what the facts mean is where maybe it gets a little bit more challenging. And going back to one of the earlier questions, is this something where you want a technologist? I wasn't. I think generally I'm in favor of the FTC and DOJ having access to experts in their own houses, people who will sit there and educate them whether a deal is pending or not about trends. So if I'm going to central casting and I'm imagining, well, what's the kind of person you want to be giving the FTC input there? There's this Wall Street Journal article a couple months ago about the new uniform in tech with the khakis and the fleece vest. That's the kind of person I'm imagining that the FTC would have to call upon. Now, whether it's done informally and you just pick up the phone and call them, or whether they actually have an office somewhere in the Constitution Center, I think that's the kind of thing where particularly for a potential competitor case, someone who knows what the trends are, who can spot them for the FTC, could be very valuable. But I don't think the framework needs to be any different.
Well, Rich, go back in time to when you were sitting at Pennsylvania Avenue, putting together cases for the government.
I'm trying to remember back that
Yeah,
far.
it
but go
was,
ahead. Yeah,
we're
okay,
trying to
good.
remember that as
Yeah,
well,
good,
though.
yeah.
But what kind of evidence would you want to see and want to be able to marshal in bringing a case against a transaction involving either a newly minted competitor or a firm that's in the, that's about to enter the market?
Well, I would start with the statute, and I would note that it says likely and substantial. And then I would look at the nascentness, is that a word, of the entrant, and I would say likely is a problem and potential, and substantial is a problem. And so here is the kind of evidence I would look to make those points. And this is really, I mean, these are hard cases, there's just no question about that, but this is what I at least came up with. I'd just start with the obvious one, is the big guy paying $1 gazillion for this? And if that's the case, that indicates likely and substantial, and I'd sure look at the documents underlying the $1 gazillion price, that's pretty obvious. The second thing is the old-fashioned way of winning an antitrust case is on the documents. And so you got to look at what the people are saying internally about how likely this company is to take off and how substantial effect it will have on them. And I'd look at the documents seriously from both sides. I'd look at patents. I'd say, well, the A side has a bunch of patents and the B side has a bunch of patents. You add those up, what's that make the future of this market look like? I would, and certainly, I think we've talked about it here, there's got to be uniqueness. Is there something distinctive about the B side here? There isn't anybody else out there doing that. I mean, there's 12 guys who come up with this company, in Palo Alto, or is there 12 guys in Los Altos who are doing the same thing? I would most certainly want to know that. I'd look at the equipment. I mean, if these two merge, will they have some sort of monopsony power in hiring the type of technocrats and technical people and scientists to do this? Will they have some kind of a dominant position or some monopsony position in the fancy equipment you have to do this? And then finally, I would go to, I would get some expert testimony as to somebody who, I might even look at an investment banker or somebody be one of the things I'd look at and say, look, the people, what do you think? I mean, does this look like a good investment going forward? I'm not sure you'd call somebody like that because they can always be cross-examined and they have opinions on everything. But nonetheless, they might be able to give you some information. And then the type of technologist who really understands these markets. But that's what I'm getting back to, is that if I was in that position, I would want somebody, and it's not me. I can barely operate my phone. But I would, somebody who knows the Silicon Valley and who knows, can look at this stuff and say, these guys really have something going here, and that's why they're paying $1 gazillion. I would want to have that kind of information as well, and that's why I thought maybe getting some generalized Silicon Valley technology help might be helpful here, but the key is substantial and the key is likely, and that's the laundry list I can think of, but maybe others have other bright ideas.
Well, I was going to just disagree respectfully with one point, Rich, and the point was made
But
earlier.
you disagree with me on every panel, unlike that.
that
Go
one-
ahead, that's all
That one's
right.
predictable.
No, but I'm over that. I'm over that last panel, Dave. I don't even think about that last one, buddy. Go
This
ahead.
point was made earlier as well.
Yeah.
I think there is very little evidentiary value in the size of the price, the amount of the price of a transaction. Sure, go look at the documents, see if you can find evidence that the whole reason for the transaction is to eliminate competition. That's fine, but you're going to do that whatever the price is. There are a whole lot of reasons why companies pay a lot of money for another company. It might be that they're just very valuable, inherently valuable. They might have great people Companies sometimes pay a lot for people. They might have a product that's going to save the acquirer a year's worth of development costs on their own that itself could have value to it. And I think that the times when I have been most frustrated with an enforcer telling me why they're suspicious about a transaction is when they were sort of superficially saying, well, this is such a high price, we can't imagine why they would be doing this if it wasn't anti-competitive.
but-
There's all kinds of ways that you can imagine they would be doing that. Go get the evidence. If you got evidence that's anti-competitive, that's fine. Otherwise, the price has absolutely no evidentiary value
All
whatsoever.
right, so you're defending the case, and the judge says, Mr. Gelfin, you've been telling me what a peanut, what a baby this company is for the last 2 days. Why are you paying, or your client paying $1 gazillion for this zero company?
Well,
I'm-
I'm probably
I'm-
not going to say it's a
and-
zero
and I'm
company if
not-
they paid $1 billion for it. I'm going to say it's a great company. It's just not eliminating competition.
All right, well, that sounds like substantial and likely to me. I mean, look, so I'm not thinking of the regular, I'm thinking somebody in black robes is gonna wonder why you're paying $1 gazillion for this company that's got no likely effect on anything.
Oh, because
That's what I'm saying.
And if I could interject, because I'm in the middle of these two, let me try to bridge the gap here, but I don't think I'll be
I
successful.
predict I'm going to
There is
agree
no
with Debbie on
chance.
this one.
I said, Mike, I
You-
cannot
you-
sit
the-
next to
the
Dave.
acqu-
That's what I
The acquirer could be uniquely able to get efficiencies out of combining the two companies that nobody else could. And a great example of that, I think, and I confess I worked on the case, and Mike will no doubt have a different view, is Genzyme Novozyme. Genzyme Novozyme was a consummated deal. I really wonder whether that would have been challenged if it wasn't consummated, because you wouldn't have known. But because it was consummated, we were able to show the efficiencies and the unique combination of companies that by working together could create a drug that companies had been working on for 50 years. So great, I can't believe I'm saying this, but President Trump brought the daughter of the CEO of the acquired firm to the State of the Union to talk about the fact that she was in college. We thought she was going to die during the case. There was nobody else who could have seen the value in that or could have developed it because they didn't have the same technology and they were coming at it. So to them, and I don't think they paid a particularly high price, that's why it wasn't reportable, but they could get value out of it that nobody else could, and it was worth it to them, and those kinds of efficiencies are meaningful. I just want to make the contrary point, which is people are talking about all the ones that the government misses. There's a lot that the government guessed on and got wrong. I mean, that's just going to happen. And my favorite example is gene therapy, where the press release talked about how it was going to be saving lives to block this merger and have these two different companies trying to innovate on gene therapy. I've always wondered if you brought them together and maybe other companies together, maybe there would have been better innovation on gene therapy because you had had a lot of really smart people in the room together. It's very hard to predict this stuff, but I think there can be real efficiencies, and that's why somebody might want to pay for a company that to the rest of the world looks not as valuable.
Much as I would love to turn this into a pharma panel where I'd feel at least on somewhat safer ground, I will, and also jump in with my own views. I'm suffering the pain of the moderator here, but I will, I want to jump to monopolization, only because there was a whole panel on Microsoft. It's been discussed, I think, either implicitly or explicitly on all of the panels, that somehow there is an opportunity for the agency to circumvent some of the restrictions in the Section 7 case law by looking at the Section 2 case law. Or in the Sherman Act. In the Sherman Act, as people have properly pointed out, the risk of competition is something that needs to be preserved. The Microsoft case talks about preserving the nascent competitor, and what better way to eliminate them than to acquire them. I think the lessons of activists potentially are exportable there as well. And so with that very loaded question, Rich, can you give me a sense of, can I bring a merger case under Section 2 and avoid a lot of the problems that you've been cataloging here?
You know, it's very Very interesting. You look at Netscape at the time that the bad conduct, and I'm going on the district court and the DC Circuit opinion, they actually had a big percentage of the number of devices out there. They were a real company. They were a startup. They'd only been around less than 2 years, but they did have a decent size, and they did look like they were on a good trajectory. You might have been able to show substantiality. But it's interesting, you get into the Section 2 case, and the word substantial is not there. You have to show a competitive effect. And it seems to me that the courts are saying if you're excluding somebody who really is a peanut, that's still excluding somebody, and you can't do that. And by the way, if you're a trial lawyer, okay, can you imagine defending a Section 2 case and say, we may have excluded Paul Dennis's company, but he is so small it doesn't make any difference. And then they'd say, Mr. Parker, so you're saying that it's open season on small companies? Well, I mean, it's not an effective way to defend a Section 2 case at all. And so there is an absence of substantiality there that I think is very important in the Clayton Act context. You mentioned activists, and I think that I don't want to get Debbie all riled up on me, but activists is, she and I have gone around on this one before. And activists, I think you need another trip to the Supreme Court to find out what that means. But there still is the concept that you've got this generic company out there, and that what you want to preserve is the possibility that they may jump in with an at-risk launch or something like that, and that somehow has a restraining power on the brand. And so that is a concept. But the difference is that sometimes the generic company is Teva, which is probably bigger than the brand, and they do have a product, and they have everything ready to go. So I'm not sure if that is any kind of a precedent here or not, except for the general proposition that the potentiality of somebody jumping in is a competitive dynamic that's worth preserving.
Well, the thing that is confusing is in almost any other kind of merger case, it's generally believed that the Clayton Act is more permissive than the Sherman Act. And it sounds like, at least in this area, we're hearing something different. Debbie, or Britt?
Yeah, I was going to say it's the substantiality requirement. Like I said, you can't defend a Section 2 case by saying the guy was really little so we can do anything we want to him. Yeah, in the Clayton Act, you hang your hat that, buying Paul Dennis's company doesn't make any difference because he doesn't make any difference. With all due respect to Paul, but that's what I'm saying. You can make that argument under 7, you really can't under 2, unless I'm missing something.
That's it?
Look, you were going to tee up a question to me, and it's in the script. So, look, I think we could debate all day long about Section 2 and Section 7, and we could debate all day long about whether Microsoft and Rambus are consistent or not consistent, and way smarter people than I will have views on this. The important point to think about for merger enforcement is the fact that there's some uncertainty about precisely what the law is on potential competition, or precisely what the law is about a monopolist buying a nascent competition. Is that scaring off the FTC from bringing cases? Can't speak to the DOJ. I'll let Dave do that if he has a view. I don't think it is. And Mallinckrodt is the best example of a case where not only were we not scared off, we were so sure of our case, or at least willing enough to take on the case, that we got a very big disgorgement figure. So at some point, the law may be a deterrent to bringing these kinds of cases, but not at the moment. Staff is not out there saying, ooh, we're not sure how we're going to write the footnote about Rambus, so we better not bring this case. They're going, is there a problem? Yes. Well, let's figure out how to write a really good complaint and tell a story to a judge, and we'll fight about the law if we have to. So far, that hasn't happened. Down the road, it might, and it might be that we're all talking here 10 years from now, as on a panel that we had earlier, folks were all saying, oh, Amex got it wrong and the world is going to come to an end because of that decision. Maybe there'll be a similar decision on potential competition that we'll all be concerned about, but that's not a deterrent right now to bringing the kinds of cases that I think folks think should be brought.
Let me, we don't have a lot of time left, and there are a couple of very good questions on areas that I wanted to touch on here. So I want to first ask a question about retrospectives. That I think there was a rather lively conversation on the last panel about retrospectives, and whether, sort of given the uncertainties that you have in these cases about how things are going to evolve, would a good strategy be to wait and see? And if they turn into Instagram that all the kids love, then bring the case. And if they turn into the Friendster or whatever, I'm hopelessly out of my depth now after two websites. But and then that's a great filter, right? The real world experience. Scott, can you give me thoughts on that?
So I think that would be dangerous. I think that would be dangerous for a number of reasons. I think, look, retrospective studies are interesting and sometimes they're important. But if you were to conclude, for example, well, Instagram has become popular, so now let's bring the case, you have to ask yourself, what's the reason that Instagram has become so good? Has Instagram become so good because inherently it was a really good product at the time it was acquired by Facebook and was actually going to become a large competitor? Or did it become a large competitor because Facebook made it a large competitor, a large presence in the market, and market events superseded what happened as a result of the transaction, and you can't really attribute the deal to the reason for Instagram's success. So you can say today, oh, YouTube is huge, and maybe we should bring a case to block the Google YouTube deal. But that doesn't answer the question as to why YouTube is great today. Is YouTube great today because it was going to be great absent the acquisition by Google? Remember, I don't know if people remember this, but back in 2005, that website was actually still funded by credit card debt by two people who were running it out of their garage. I mean, was that company likely to become really large as a result of, if it wasn't acquired by Google, or did it become large because it had access to the resources of a Google to make it large? So I think going back and doing that sort of retrospective is very problematic. You can draw very erroneous conclusions as a result of it. I'm not suggesting that retrospectives are bad, but I think in technology markets where things change very rapidly, where there are a lot of reasons why something might become successful or might fail, you have to be really careful to attribute the deal to the reason of the success of the competitor that was acquired. You can't just say, well, the company became big, therefore we should probably have challenged the deal in the first place. I think you would get a tremendous number of false positives.
Well, I think Professor Yun said that, I hate to be quoting him, God knows, probably some false premise with my question, but he said everybody's for retrospectives. Is everybody here sort of for retrospectives the way Scott apparently is?
Yeah, just one more quick thing. I'm not in favor of retrospectives from the perspective per se. What I actually think, and I had mentioned this earlier, what I think the agency should do, because there seems to be a lot of confusion by a lot of people who are actually not practicing. Well, do the agencies just not understand how to do these deals? Well, they actually do understand how to do these deals. So how do you rectify the problem that no one knows that the agencies understands how to do the deals, but they're actually doing them correctly? They should issue more closing statements. The agency should explain to the public, what did you look at? Why did you look at it? Why did you reach the conclusion you reached? What other conclusion could you have reached? Some of the best decisions that have come out of the FTC, in my opinion, over the course of the last 15 years are Genzyme, Novozyme, where there was an extraordinarily detailed closing statement, and the cruise line case. And those are cases where the FTC actively took steps to explain to the rest of the market why they took the actions they did. Those are the sorts of things that I think would help increase knowledge as opposed to just going back and saying, well, something's successful now, we should go back and retrospectively challenge it.
Anybody else have something on retrospectives? I'd love to, if Rich wouldn't use our closing statements against us when we sue him, it would probably be much more, the agency would be more prolific in that regard.
So I'll just add, I agree closing statements are really valuable and would encourage the commission to do those very often, maybe even on the level the way some of the Europeans do it, at the EC level, some of the member states do it. I think it's a great idea. I also think that internal retrospectives, and I worked for Bill Kovacic, who obviously spent a lot of time thinking about the FTC as an institution. And I think there's value to the FTC doing retrospective studies, even if you don't release it to us. Obviously, I'd prefer you would release it to us. But I think that there's real value to being able to have the staff go back and look at what they did and see what they missed, see what they did well. I think sometimes you can learn an awful lot from that to give you confidence to go ahead. And so I would encourage, even if you're never going to tell me what you find, for you all to go back and think about ways that you did well on this deal, and here's where you fell a little bit short. And certainly having the 5B authority to be able to get data from parties once transactions have closed. I know there's paperwork involved. You have to go to OMB. It's very complicated. I won't pretend to understand it. But having that ability, I think, means you'd be able to really do something meaningful, even if you never tell me about it.
You know, I agree with that, but I have to say, like any scientific work, a study needs to be unbiased. And when you've got the people who are making the decisions, studying the outcome of the decisions, that is not an unbiased study. So I think it's great. I think if the agencies want to do it, it's great. I think they've got a lot on their plates. And it's hard to go back and look at old stuff when you got a bunch of new stuff coming in.
Particularly when David's telling you to go really fast.
Yeah, and you got to go really fast. You got to go really fast, Bilal. I hope you got that down. So, but you know, other people need to do it, and we've heard some examples on the panels today. And even though I don't agree with everything people have been saying, I definitely agree with the scholarship of it all. Study this. Convince other people. Don't just say your opinions. Do the work. Make it verifiable, replicatable, all the things that scientific work is. Be unbiased, and eventually this body of work will lead to conclusions.
Just one quick sentence. I think the commission does that all the time. They don't call it a study. They look at the industry again in the next deal. And as part of that, they are looking at whether or not the predictions of the last deal are right. And I think of one in particular, Mike and I worked on it, where there was controversy over the first deal. And when we went back to ask folks, customers, how did it turn out? They 2-1 said, oh, this was a great deal. This was a deal that had been controversial as to whether or not it should be cleared. And the customers all said, yeah, all the efficiencies, we got it. We got lower prices. We can show you. It's in our documents. So, I mean, they're doing that sort of thing, you know, as they're going along.
I'm sorry, I'm not a panelist here, so I won't, maybe I should say it in the form of a question, Jeopardy style here. But the, I think Dave's point, maybe if you can expand on that, is how do you solve for the problem of the investigators or the confirmation bias that's inherent in those kind of analyses?
Yeah, I think that's a big problem when people look at their own work and they go back and that's what they're trying to show. And, you know, it's necessarily going to be untransparent to the public if the agencies are relying on confidential data. They can't publish that data. I don't know what the answer is to that. I think there's value to it. I'm not saying people shouldn't do it to the extent they have time and resources to do it, but I do think, you know, people would be skeptical of the results of, you know, work being done by an organization studying its own success rate.
I don't know. People quote the divestiture study back a lot. I mean, look, yes, on the margin, but, you know, if that was just the agency trying to show that it had done great, I think it would have come up with a higher percentage of success numbers.
I think it's a very flawed study.
We tried to have
honestly.
more
That's actually
input
one of the
into
things
that.
I have in mind as I'm thinking about this.
All right, we'll to avoid too much thread drift here, I wanted to ask, there was one question that came in, more on this technologist, which I think just is something that spurs so much interest. One of the questions was, if we had a budget, which is almost hypothetical, not even worth contemplating, but it was large enough to add 10 people to the agency. Do you put them, or any portion of those, into people with this kind of expertise, given sort of what's happened over the last 3 days here, what we've heard over the last 3 days? Is it more attorneys? You know, I probably could answer the question about more economists, more commissioners. There are a lot of possibilities as you could put the resources that I might have my own views on. But I mean, seriously, I think it is a good question because it asks, what is the need from the outside perspective at the agency?
I got asked that question by the chairwoman. If I could have $5 million, what would I do with it? I mean, it was a serious question because it was a time when we thought we might get some special bonus. And I said, surprisingly, I'm sure to the lawyers in the room, sorry, no offense, I said more economists. And the reason is A, we don't have enough of them on the cases, and B, I would love a group of economists who could use the data and do studies, and maybe hire outside economists to do the studies as well. That more studies was the one thing I would want to spend money on.
Anybody else have thoughts on that?
No, I agree with, particularly if you're talking about technology deals, the one thing, and Debbie and I worked on a deal where there was, when she was at the commission, there was just a tremendous amount of data. That is one thing that is different about technology deals than about other transactions. There's a tremendous amount of data sometimes, and it's very difficult for the FTC to get up to speed on how to analyze the data really quickly. It would both facilitate, Dave's desire to get transactions closed more quickly where they deserve to be closed, and probably would help the FTC make better decisions on whether or not there's a likelihood of effects if there were people who can actually, do the type of data analytics that you need to do really rapidly.
I would clone Ted Hassey and hire 10 of him. And I would do it so you have even greater, yeah, I know he's up there. I always pick somebody in the audience, when I kiss up to somebody. I would do it because you always need more capable trial lawyers, I think, in any organization whose mission is law enforcement and bringing cases. And I would do it not just so you're even more effective in court, because you're already very effective in court. The government's winning most of its cases in recent years. But also because you need experienced people to make judgments about when it's time to cut it off. And this is not a case we can bring. It's not winnable. There's really no problem here. So that's what I would do. I would hire 10 of that guy.
Or that's half an economist based on the bills we're getting for experts, so.
I just want to say I totally agree with Dave.
I'm dumbfounded now. I mean, maybe that's
Maybe 9 Ted Hasseys and 100.
I feel like we've finally reached consensus on our panel. We have a couple of minutes to go. I was just wondering if anybody had anything that they wanted to add as we go before we close out here.
I'd like to add a comment to the law students in the audience, because I think there might be some of you. This is a fabulous area of law to practice in. There is so much going on. I hope you've seen through the interactions that have taken place today how great a bar this is, and how people really think hard about these issues, how they have very civil discourse about it. And organizing things like this, Bilal, where people can come together and debate these issues, try to inform the agency about the different perspectives, bringing scholars together with practitioners, with enforcers. I hope law students in the audience appreciate how wonderful an area of practice this is. So that'll be my closing remark.
Well, maybe that's a good place to end. I will say that I feel very privileged to have had the chance to, I disagree with all of you regularly on substance, but have learned a lot from you, and I appreciate the opportunity to have been able to moderate this panel.
Thanks, Mike.
Thanks.
Good work, Debbie, as always. Hey, Rich, that was great.
Yeah, we got the next one coming up. Hey, what time is that on?
After a long but informative 3 days of hearings, we have one final event that I hope everybody could sit for and focus for just the last 10 minutes. We have quite a treat. Judge Douglas Ginsburg is going to be giving closing remarks. As many of you know, Judge Ginsburg is a senior judge now on the U.S. Court of Appeals for the D.C. Circuit, which he was the chief judge from 2001 to 2008. He's also a professor here at the Antonin Scalia Law School here at George Mason University. And in the 1980s, he was the Assistant Attorney General, head of the Antitrust Division. It may not make the first paragraph of his bio, but one of his finer moments was serving as my boss as a law clerk from 2008 to 2009 on the D.C. Circuit. So it's a pleasure for me to introduce Judge Ginsburg to close us out.
Thank you, Judge. Thank you. Well, you've had a long day, and it's been a long several days, so I'm not going to detain you for very long. But I did want to provide a little perspective from the realm of the gray hairs. These hearings, as I think you may know a little bit about, are essentially modeled after hearings that were convened by Robert Potofsky, then chairman of the FTC, in 1995. And in those hearings, the commission considered questions, some of which are familiar to us today, such as the broad general one was then and is now, how antitrust law should be adapted in light of, and whether it should be adapted in light of developments of innovation and increasing, at that time, increasing globalization. So my brief remarks today are going to focus on the broad aspirations of this kind of review that's taken place periodically. From the 1995 hearings to the report and recommendations of the Antitrust Modernization Commission in 2007 to the hearings that have been conducted these last few weeks, the authorities, the commission in particular, have had to confront whether and how existing tools should be adjusted to meet new market realities. It's hard to get into this subject with without first pausing for a moment to honor the work of Bob Potofsky, who, as many of you know, passed away just last week. Bob was a commissioner of the FTC starting in 1978 for 3 years, and then again in 1995 came back as chairman until 2001, a pivotal time that shaped the commission and brought the agency to new prominence. Bob had too many accomplishments to be recounted fully here, but more important than any of those in particular was his approach to antitrust enforcement, which was sharp and thoughtful and crucial to the Commission's ability to confront new challenges that it faced at the dawn of the 21st century. Throughout his chairmanship, Bob demonstrated that a measured approach to competition policy could reap great rewards for consumers. He vastly improved the Commission's administrative processes in several ways, one important example being creating a fast track for administrative litigation that significantly improved the Commission's ability to resolve antitrust cases in a timely fashion. After leaving in 2001, Bob went back to Georgetown University Law School and continued to teach and write about antitrust, teach antitrust and write about it until the very end of his career. And today it's thanks to many of his accomplishments at the FTC, and in no small part to the precedent that he set with the hearings in 1995, that the Commission has been able to bring together really top people in academia and government, in law and in economics, as well as stakeholders and members of the public to consider the challenging issues that you all have been dealing with. The 1995 hearings were officially called the Global and Innovation-Based Competition Hearings, and they were held over a period of 2 months. That may seem even more ambitious than the rather tight schedule that Bilal has been set out for all of us over the next several months. Tim Uris noted some time ago, Tim himself a former chairman of the FTC and a longstanding member of the Antonin Scalia Law Faculty here, a while ago noted that through those hearings, the chairman took advantage of the unique features of the FTC, bringing together, as it does, in one agency, not just the commissioners chosen on a bipartisan basis, but the administrative law judges, attorneys, the now 80, at that point I think 60 PhD economists on the staff, making the agency one of the most important industrial organization economics departments in the world. Bring all of that together with its power to initiate studies, its 6B authority to initiate studies and report to the public and to the Congress on matters of competition concern. The subjects taken up in 1995 ranged pretty broadly in substance as they do this time around. Just to give you a sense of how times have changed and to some degree have not changed, consider these selected topic headings from the agenda. How should antitrust define current generation markets when firms compete on innovation, or product attributes, close paren, as much as price? Or what roles do antitrust and intellectual property protection play in promoting innovation and competition? You could have reused these below. Finally, how do computer companies compete? How do the network and interoperability aspects of the industry affect competition? Throughout those hearings, the Commission heard advice from economists, from legal scholars, from informed members of the public. And then the staff of the Commission distilled those contributions into several projects, some of which have lasting application, not just influence, but application today. For example, after the hearings, the FTC put together with the Department of Justice, revised the guidelines on efficiencies in merger review and made more precise and more demanding the showings that had to be made to prove that claimed efficiencies were indeed merger specific. The FTC staff also embarked on a project with the Antitrust Division, the Joint Venture Project, in order to clarify the agency's policies regarding collaborations among competitors and resulting in the guidelines that were issued in 2000. Not long after, the Congress in 2002 wanted to know for itself whether the antitrust laws needed to be updated in some way and created the Antitrust Modernization Commission through an act of that title in 2002, creating and tasking a new and temporary group to investigate what should and should not be changed in light particularly of globalization and of rapid technological change, another familiar theme today. And that was a bipartisan 12-member commission that invited the public to recommend topics for its investigation. The AMC issued its report and recommendations in 2007. And as with the 1995 hearings and those now underway, the AMC's report covered the whole range of topics, from criminal remedies to intellectual property, to whether the Congress should repeal the Robinson-Patman Act. And the report concluded that although there were ways in which antitrust enforcement could be improved, the current antitrust laws were, quote, sound, close quote, and did not require entirely new or different rules to address the then so-called new economy, in which, and I'm quoting the report, innovation, intellectual property, and technological change are central features. Pretty contemporary account, frankly. Of particular relevance today, the AMC concluded that because antitrust law is flexible and open to new economic thinking, the agencies and the courts have the tools that they need in order properly to assess new marketplace developments and competition issues as they arise. Now, in the current set of hearings, we've heard, and we're going to continue to hear from a wide range of experts and stakeholders about how the economy has changed since 1995 and indeed even since 2007. And it's true that even a decade ago, the agencies likely could not have foreseen some of the competition issues now associated with big data, with privacy, with algorithms, and so on. And indeed, the first case involving a platform business to reach the Supreme Court was decided only a few months ago. So this is all fairly new stuff. With these new market realities, some observers are now calling for really significant changes in the focus of antitrust law. And I'm going to highlight just a couple of them that have emerged in recent years, and we've all heard, read, and perhaps said something about one or both of them. And the first is challenges to the consumer welfare standard. The 1995 hearings did not call into doubt the so-called core aspects of antitrust enforcement regimes, which were said to have, quote, served the country well, close quote. Rather, they addressed adjustments that the agency had to make, or thought they should make, in order to ensure vigorous competition and consumer choice. Now, as Chairman Simons noted when he gave his opening remarks a couple of weeks ago, now they're hearing calls to expand beyond the consumer welfare standard and to consider all manner of other concerns ranging from economic inequality all the way back, and I take the word back advisedly, to a concern with the sheer size of firms, a consideration that was explicitly repudiated in 1981, that was unmourned in 1995 and 2007, but here in 2018 is the subject of a forthcoming book by Tom Wu next month called The Curse of Bigness. Second is the role of intellectual property. As new products are devised to take advantage of digital technology, the importance of IP rights has increased throughout the economy. But the potential for anti-competitive abuse of intellectual property has also become an increasingly important antitrust concern. And there's certain to be a continued debate throughout the present hearings about whether the historical protection that we've afforded to intellectual property should be compromised in order to balance incentives to innovate with market access for competitors. Whether U.S. firms continue to dominate technology markets worldwide is surely at stake in the resolution of that question. Now, I'm not going to belabor you at this late hour with my views on these matters. They have been submitted to the Commission in the remarks submitted by the Global Antitrust Issue, to which I'm a signatory. But they are important issues on which a lot of perspectives are going to be brought to bear. In closing, I just want to leave you with some conclusions I'm recycling from the report in 1995. I think they're still relevant. This is the staff's conclusion. Effective antitrust enforcement requires rules and processes that facilitate accurate judgments in the face of inherent uncertainty. Developing those new rules depends on a cautious approach, reliance on specific facts, a willingness to learn from the past, transparent decision-making, and the articulation of competition values whenever antitrust policy is being made. I don't think we can do better than that. I hope we can do that well this time around. Thank you for your attention.